lecture on Irish constitutional law, specifically focusing on taxation in the Irish constitutional framework and an interesting addition to an extension thereof of taxation being possibly the largest corpus of legislation in the Republic, um, and the usage of ministerial statements with the usage of taxation legislation as a good metric to gauge the use of ministerial statements from. Constitutional provisions concerning taxation. Article 15.2.1 vests the sole power of making laws inclusive of tax laws in the Parliament. In MacDonald and Bordnagon, taxation without a valid lawful basis is unconstitutional. In City View Press and on Corla Uluma, taxation has to be authorised explicitly by the Oireachtas, and no other body within the state can raise such taxes. Article 40.3 protects personal rights, inclusive of property rights in Ireland. In Brennan and Attorney General, the court considered whether taxation amounted to a confiscation of wealth, and ruled that on policy grounds, of course, taxation was necessary, but it must be proportionate and fair in nature, respectful of personal rights, inclusive of property rights, balancing these rights with that interest of public policy. In Article 40.1, the guarantee of equality before the law is frequently invoked in tax law, specifically that case of Madigan and Attorney General, which challenged the basis on discrimination between different categories of taxpayers. And these categories would be that of different classes of taxpayers. Article 41, the family, was activated in Murphy and Attorney General, where the disadvantaging of unmarried couples as opposed to unmarried cohabitants was litigated before the courts. Article 43 concerns the protection of private property and rights to economic activity relevant to taxation legislation in the Republic of Ireland and its interaction with constitutional law, as is Article 45, which provides guidance on social justice and economic fairness, not yet significantly explored in Irish constitutional jurisprudence, but nonetheless remains articles of the constitutions and therefore hold constitutional legal value. The 1890 Revenue Regulation Act was the initial piece of legislation governing revenue raising in Ireland. The initial Department of Finance Act 1924 governed the establishment of a revenue raising arm of the newly founded state, and the Finance Act of 2008 transferred the previous collection of revenue from the Attorney General to a Collector General. Prior to the establishment of the Free State, taxes had been collected in the name of the Crown. Annual financial acts are prepared by government and passed, or not, as the case may be, by Parliament. And each financial act governs the administration of tax revenue, tax adjustments, and tax assessments by the revenue, which is the agency through which the primary acts are administered for the purposes of tax collection. Tax is also assessed in the Taxes Consolidation Act of 1997, sections 932 to 949. Appeals pursuant to natural law and fair procedure in Irish constitutional law are available internally to appeal commissioners, the Circuit Court, and the High Court. Appeal commissioners are independent of the revenue. Judicial power and taxes consider attachment orders, and the Orange and Revenue Commissioner's case held that attachment orders are leviable against bank accounts, but they are not leviable against the employer. And therefore, the only bank accounts to which they would be leviable would be that of the employee for tax unpaid. There is no legal liability for tax default unless the taxpayer defaults, and there will be an intervention by the courts in the event of an unfair or erroneous tax or tax decision, tax assessment, and therefore it is likely the case that the revenue commissions in their internal appeals and the external appeals commissioner for taxes will also consider such intervention in the event of an unfair or an erroneous tax assessment, or tax appraisal. In the Kennedy and Hearn case, the Irish courts held that courts may stop improper tax recovery actions. In the Deegan and Hearn case, where a taxpayer misses deadlines for appeal internally, they are unable to challenge that appeal or indeed initial assessment at a later date, unless the revenue acts arbitrarily, and such appeal shall then be justiciable in the Irish courts and may be granted. Further, this case held that PAYE deductions are upheld as a duty of employers to be deducted, and in this case the taxpayer was compensated for abusive tax collection by their employee under the auspices of the PAYE scheme. In Daly and Revenue Commissioners, the withholding of tax on professional fees was ruled unconstitutional as it was a double tax payment. It also permanently reduced funds, it was deemed arbitrary and unfair, and it was deemed to impermissibly interfere with the property rights that the courts see fit to balance in the general provision of constitutional jurisprudence, balancing said same rights with the importance of public policy in the general corpus of tax jurisprudence and constitutional jurisprudence. In McLaughlin and Tweed, tax penalties are civil obligations and they are not criminal sanctions in the Republic of Ireland. In Brown and Attorney General, benefit in kind taxes were upheld, and any perceived disadvantages, actual or otherwise, to the individual arose from personal choice rather than the state's tax policy, and therefore the tax on benefit in kind was upheld as fair. The Muckley and Ireland case considered a social welfare and tax anomaly for married mothers and unmarried mothers. This disparity was upheld, as it was ruled by the courts that the Oireachtas may distinguish between social groups. In Brennan and Attorney General, the Griffith evaluation tax was struck down, as the courts ruled it to be outdated and discriminatory in fashion. In Doyle and on Taoiseach, a levy on butchers and cattle exporters of 2% was ruled to be ultra vires, and it suffered this fatal direction on the courts as a result of having unfair application, and therefore it's proof that the courts, for a tax as low as that of 2%, be it levy, are prepared to take a strike, so as to remove legislation from Law Ireland in the event of its unconstitutionality as a result of being ultra vires. And furthermore, the unfair application renders that the courts will leave no doubt as to the universal application of a tax, and it shall not be arbitrary in nature. Perhaps in this case tax would not have been ruled to have been unfairly applied, was it broadly applied to a general category of exporters and a general category of agents in the food preparatory or indeed agriculture business. In the McKenna and Taoiseach case, it was held that the executive has a constraint on the use of exchequer funding in a referendum. Such exchequer funding must be non-partisan and apolitical, and though this is not specifically that of a tax case, it does direct the executive on the use of exchequer funding, which is tax in the state and for the state's purposes, specifically as to political purposes and where they marry with the legal function of a referendum.